Law of tort. Negligence. Negligence implies absence of intention to cause the harm complained of. It means careless or unreasonable conduct. But merely unreasonable conduct without damage is not actionable, though it may be a punishable offense. Such conduct, when followed, can cause harm to another, gives rise to liability for negligence. It may be pointed out that negligence may mean a mental element in tortious liability, or it may mean an independent tort. Basically, there are two theories about the negligence in the law of tort. They are subjective theory. According to this theory of Solomon, negligence denotes state of mind. This state of mind varies from person to person, and the person is liable only for his intentional act only and not otherwise. It involves a personal element. If a person has acted on the best of his ability, then he cannot be held liable for negligence. Objective theory. According to this theory of Pollock, negligence is a type of conduct which a reasonable man can avoid with a reasonable degree of care and caution. Negligence has been recognized as independent tort by the House of Lords in the case of DONOGHUE versus STEVENSON in 1932. This case treats negligence as a type of conduct and not a particular state of mind. In this case, A purchased a bottle of ginger beer from a retailer for the appellant, a lady friend. Some of the contents were poured in a tumbler and she consumed the same. When the remaining content of the bottle were poured into her tumbler, the decomposed body of a snail floated out with her ginger beer. The appellant alleged that she seriously suffered in her health in consequence of having drunk a part of the contaminated contents. The bottle was of dark opaque glass and closed with a metal cap. So that the content could not be ascertained by inspection. She brought an action against the manufacturer for the damage. One of the defenses pleaded by the defendant was that he did not owe any duty of care towards the plaintiff. The House of Lords held that the manufacturer owed her a duty to take care that the bottle did not contain any noxious matter, and that he would be liable on the breach of the duty. According to Lord Atkin, a manufacturer of products which he sells in such a form as to show that he intends them to reach the ultimate customer in the form in which they left him, with no reasonable possibility of intermediate examination, and with the knowledge that the absence of reasonable care in the preparation or putting up of the product will result in any injury to the consumer's life or property, owes a duty to the consumer to take that reasonable care. The tort of negligence is therefore complex and fluid because in determining the liability in negligence, issues like duty, care, causation, remoteness of damage are to be analyzed in any given case. Essentials of negligence. First, duty to take care. One of the essential conditions of liability for negligence is that the defendant owed a legal duty towards the plaintiff. The following case law will throw some light upon the essential element. In Grant vs. Australian Knitting Mills Limited, the plaintiff purchased 2 sets of woolen underwear from a retailer and contracted a skin disease by wearing an underwear. The woolen underwear contained an excess of sulfates which the manufacturers negligently failed to remove while washing them. The manufacturer were held liable as they failed to perform their duty to take care. Essential second, duty to whom? DONOGHUE vs. STEVENSON carried the idea further and expanded the scope of duty, saying that the duty so raised extend to your neighbor. Explaining so as to who is my neighbor, Lord Atkins said that the answer must be the person who are so closely and directly affected by my act, and I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the act or omission which are called in actions. Essential third, duty must be towards the plaintiff. It is not sufficient that the defendant owed a duty to take care. It must also be established that the defendant owed a duty of care towards the plaintiff. In Borhill vs. Young, the plaintiff, a fishwife, alighted from a tram car while she was being helped in putting her basket on her back. A motorcyclist, after passing the tram, collided with a motor car at the distance of 15 yards on the other side of the tram and died instantly. The plaintiff could see neither the disease nor the accident, as the tram was standing between her and the place of accident. She had simply heard about the collision, and after the dead body had been removed, she went to the place and saw blood left on the road. Consequently, she suffered a nervous shock and gave birth to a stillborn child of 8 months. She sued the representatives of the deceased motorcyclist. It was held that the deceased had no duty of care towards the plaintiff and held she could not claim damages. Essential 4. Breach of duty to take care. Yet another essential condition for the liability in negligence is that the plaintiff must prove that the defendant committed a breach of duty to take care or he failed to perform that duty. In Municipal Corporation of Delhi vs. Subhagwanti, AIR 1966 SC 1750, a clock tower in the heart of the Chandni Chowk, Delhi, collapsed, causing the death of number of persons. The structure was 80-year-old, whereas its normal life was 40 to 45 years. The Municipal Corporation of Delhi, having the control of the structure, failed to take care and was therefore liable. Essential 5th, consequent damage or consequential harm to the plaintiff. The last essential requisite for the tort of negligence is that the damage caused to the plaintiff was the result of the breach of duty. The harm may be physical harm, that is harm to body, or harm to reputation, or harm to property, that is land and building and right and interest pertaining thereto, and his goods, or economic loss, and mental harm or nervous shock. In Achyut Rao Hari Bhau Khodwa versus State of Maharashtra 1966, a cotton mop was left inside the body by the negligence of the doctor. The doctor was held liable. Defenses for negligence. Defense number 1, contributory negligence. It was the common law rule that anyone who by his own negligence contributed to the injury or which he complains cannot maintain an action against another in respect of it, because he will be considered in law to be author of his wrong. Second, act of God or vis major. If it's such a direct, violent, sudden and irresistible act of nature as could not, by any amount of human foresight, have been foreseen, or if foreseen, could not by any amount of human care and skill have been registered, such as storm, extraordinary fall of rain, extraordinary high tide, earthquake, etc. Defense number 3, inevitable accident. Inevitable accident also works as a defense of negligence. An inevitable accident is that which could not possibly be prevented by the exercise of ordinary care, caution and skill. It means accident physically unavoidable. The topic of negligence is fully covered in this video. You can replay this video to understand better. Subscribe for the future content related to law. Thank you.